On behalf of Economic Laws Practice, I'm delighted to welcome you to the second episode of Climate Capital, a CBAM series. This series has been specifically designed for Indian businesses who are engaging with the European Union's Carbon Border Adjustment Mechanism, better known as the CBAM. Our objective is to move beyond a high-level understanding of CBAM and focus on what it means in practice for Indian industry, particularly for sectors such as iron, steel, aluminum, and other CBAM-exposed value chains. If you joined us in our first session, we had set the broader policy and strategic context for CBAM. The discussion had focused on CBAM, the EU Green Deal, and India-EU industrial cooperation. We looked at how the CBAM fits within the EU's broader trade and climate policy architecture and why it matters for Indian exporters, even though the formal legal obligations sit with EU importers. Today, in episode 2, we move from the why of CBAM to the how. We will unpack the legal and operational architecture of the mechanism, examine what EU importers actually expect from their suppliers, and discuss the practical steps Indian exporters should be taking now. To help us navigate these complicated issues, we are privileged to have with us two distinguished speakers who bring both the EU and the Indian perspectives to the discussion. Byron Maniatis is a partner in Hogan Lovells Cadwaladers International Trade Practice in Brussels. His practice focuses on trade compliance, trade defense, trade controls, and dispute settlement. He regularly represents clients before EU institutions and courts and advises companies on ESG-driven trade barriers, including the CBAM. We're also joined by Parthsarathi, a partner at Economic Laws Practice. Parth is a partner in ELP's international trade, competition law, and data privacy practices. He advises clients on a range of issues within these areas. Parth has also been advising companies on issues relating to trade and climate, including the CBAM, as well as the development of India's CCTS, that is the Carbon Credit Trading Scheme. To start with, Byron will walk us through the legal architecture of the CBAM. This will be followed by a panel discussion between Byron and Parth, where we'll unpack the pertinent issues surrounding importer expectations, contracts, pricing, documentation, etc. Please feel free to add your questions in the Q&A chat box below. We will address this at the end of the panel discussion. With that, let me thank you once again for joining us for episode 2 of Climate Capital. Byron, the floor is all yours.
Thank you very much, Naghm, for this introduction, and thanks a lot to ELP also for having me on this webinar. It's a pleasure to speak with you today on the CBAM. I will start with a brief discussion of the CBAM architecture. I'll also touch upon practical impacts on exporters to the EU of CBAM-covered goods. We'll briefly discuss some risks involved in export of these goods to the EU, touching upon also enforcement and litigation scenarios. And finally, we'll briefly discuss the proposed modification to the CBAM with the potential extension to further downstream goods. Starting with the CBAM architecture, I think it's useful to take a step back and discuss what CBAM is and why it exists. It's an environmental policy instrument that has been designed by the EU to prevent carbon leakage by ensuring that imported carbon-intensive goods bear a carbon cost that is equivalent to that borne by EU producers under the EU emissions trading system, the EU ETS. It operates alongside a progressive phase-out of free EU ETS allowances for CBAM-covered sectors between 2026 and 2034. It's important to keep in mind that the CBAM actually has multiple aims. One of it, and it's a genuine one, is to address the climate impact of consumption in the EU, alongside several other EU policy measures that have been implemented over several years now. It also aims to encourage low carbon production in third countries, while at the same time, and this is also important, leveling the playing field for EU industries. And in this context, it can be seen from a wider angle with several measures that the EU has been imposing more recently to protect the EU industries and EU economies, often relying on wider trade measures addressing genuine concerns, while at the same time trying to increase barriers to entry to the European market. The sectors that are covered by CBAM are currently limited to 6 broad sectors, as iron and steel, aluminium, cement, fertilizers, hydrogen, and electricity. And these sectors have been specifically selected because they're considered to be at a high risk of carbon leakage. What is carbon leakage? That's basically that there is a fear, but also it has been established that due to some of these environmental and climate measures that the EU has been imposing on its own industries, production has gradually shifted away from the EU to jurisdictions where there are lower requirements from an environment and climate perspective. This, of course, has to also be seen together with moving away from European industries due to other concerns, especially high energy costs. But then again, there is a mixture with the higher energy costs that are again linked to carbon measures that are being imposed by the EU. This will be discussed a little bit later in this presentation. There has been a proposed extension to about 180 additional downstream steel and aluminium intensive products, which is currently targeted for the 1st of January 2028. It's currently going through the EU legislative process, and then we'll discuss it in a bit more detail in a few minutes. CBAM has been around for some time now. There was first a transitional phase that started on the 1st of October 2023 and ended on the 31st of December 2025, which was a little bit of a learning phase. It was a learning phase for EU importers, a learning phase for exporters to the EU, but also for the European Commission and national competent authorities, where there was a quarterly reporting of embedded emissions, no financial obligations, and where importers could rely quite easily on default values. But the idea was also for exporters to start preparing to be able to be in a position to report actual values. The definitive phase has now started since the 1st of January 2026, and now financial obligations have begun on importers of CBAM covered goods. Also, only authorized CBAM declarants are allowed to import in-scope CBAM goods, with the important caveat there also with respect to the financial obligation is that there is the minimum threshold of 50 tons of accumulated net mass per annum, whereby if you fall below that, then you have no financial obligations. There's also been a shifting from the transitional phase to the definitive phase, whereby the reporting shifted from quarterly CBAM declarations to annual CBAM declarations. And the first declaration, which also will coincide to the first certificate surrender obligation, is due by the 30th of September 2027. So there's still a little bit of time. That will cover imports that took place in 2026. Then every year, there will be that deadline in the 30th of September for the preceding year of imports. Touching upon a bit the notion of CBAM certificates, basically EU declarants must purchase CBAM certificates that will be priced to mirror the EU ETS allowance price. The EU ETS allowances, that's basically what EU industries that fall under the EU ETS have to surrender for their carbon emissions. There is then so somewhat of an equivalent that's referred to as a CBAM certificate, and the pricing thereof is really based on the EU ETS allowance price. There will be a quarterly average for 2026 imports, and going on next year in 2027, that will be a weekly average price for the CBAM certificates. The first two CBAM certificate prices have already been published by the European Commission. That gives you a little bit of an idea. For the first quarter of 2026, the quarterly average is 75.36 euros per ton of CO2 equivalent. And for the second quarter, this was published just under 10 days ago. On the 6th of July, there the quarterly average is 75.28 euros per CO2 ton equivalent. So as you can see, it currently is hovering just above 75 euros, but of course that can change quite a bit as EU ETS allowance prices will change. Certificate sales will start on the 1st of February 2027, and it's the importers, the declarants, that have to purchase these. And there's a quarterly holding requirement on importers of 50% of the cumulative embedded emissions that the importers have imported. And finally, for the CBAM certificate price that will have to be surrendered, there is also a deduction that will be available for CBAM importers for any carbon price that was effectively paid in the country of origin. The Commission is currently undertaking, is looking into the legislation to be adopted in this context, and on how exactly that will be taken into account and priced into the CBAM certificates to be surrendered by importers. Now, what is the practical impact on exporters? First, and most importantly, it is the emissions data and documentation burden. From now, 2026 onwards, embedded emissions in CBAM declarations will have to be supported by verified actual data. First, the producers in the exporting country, in this case India, will have to calculate their actual emissions data that will then have to be verified by accredited verifiers operating under CBAM specific verification principles, which are aligned to those of the EU ETS. And where verified data is unavailable, importers will still be able to rely on country and product specific default values. However, these default values are not very beneficial to rely on because they can be 30 to 80% higher than actual emissions for efficient producers, creating a potentially severe competitive penalty. And moreover, there will be a progressive markup over the years, moving to 30% in 2028 onwards to disincentivize relying on default values. As discussed, the legal obligation under the CBAM framework lies on EU importers alone. It's only the authorized CBAM declarant that can be held liable for misdeclared values or under-declaring or not declaring at all. But in practice, what we are seeing already now and what we're expecting more in the future is that the economic and contractual liability burden is being passed to upstream suppliers. And how is this affecting the third country suppliers? First and foremost, through lower prices. We're seeing stricter contractual terms, and also importers that are becoming more and more selective with their suppliers. First and foremost, relying on suppliers that are able, or at least have a process in place that they will be able to supply actual data. And then also increasingly seeing that importers are comparing the actual data from the different suppliers in order to be able to have the lowest potential CBAM cost. And in this context, CBAM is mostly discussed, even though there's all these sectors that are covered, it's mostly discussed in the context of iron and steel, as well as the aluminium sectors. And these are also by far the most exposed Indian sectors and represent really the vast majority of the exports of CBAM goods from India to the EU. Now, there are a number of risks that we briefly touched upon already that are being faced and will be faced by third country suppliers to the EU, including Indian producers. First, and a very simple one, if a producer, an exporter, cannot supply verified emissions data, the EU declarant will have to fall back on default values. And as we discussed, these are deliberately conservative and carry a rising markup, effectively competitively penalizing the supplier. So either the supplier will have to significantly reduce their prices, which then can further down the line have other issues in the context of potential trade remedy investigations on a product, as that increases risks of dumping margins being higher, but it also has an economic impact. We are seeing increasing issues, as discussed, also of contractual exposure, where EU buyers, and the stronger the buyer, the more impact that this can have, are inserting CBAM specific clauses into supply contracts. And these range from warranties, audit rights, notification duties. I imagine that we'll discuss this in more detail a little bit further in this webinar. but also indemnity clauses. And the risk due to these contractual clauses that we are seeing becomes asymmetric, because whereas in theory and under the CBAM framework, it's the declarant that bears the penalty, this indemnity is being pushed onto the suppliers through indemnity clauses that claw back the liability from the supplier. And finally, there's also a reputational risk involved, of course, in case there are issues. It will fairly quickly be known in the market what suppliers are able to provide actual data, what suppliers will have verified data, if there's any issues with the data of those suppliers once that it is being reviewed by the European Commission or the national competent authorities. That will all have an impact on the reputation of particular suppliers, which might be difficult to recover from once any issues have been established. Moving from the risk to potential enforcement and litigation scenarios, and also explaining a bit how the architecture works. That is that there's a different role there, but a kind of a dual role. You have on the one hand the European Commission that plays an important role, and also the national competent authorities of the EU member states. The EU being a little bit complicated in its setup, each EU member state has its own national competent authority, which is responsible for first authorizing CBAM declarants, managing the national CBAM registry accounts, conducting inspections, but also the enforcement that is really on the national NCA. So any penalties that will be imposed on then the CBAM declarants and the importers in the EU, that will be done by the national competent authorities. We're seeing this in various other areas of EU law, customs law, sanctions and export controls enforcement. It's always the EU member states where that are responsible for enforcement, but that also means that we see a patchwork with inconsistencies whereby some EU member states are more aggressive or stricter with their enforcement. Penalties may be different to a certain level, and consequences may be different. So also there, we might be seeing some trade diversion to different member states, especially as experience grows, depending on how this enforcement may or may not differ between member states. Then we have the European Commission, which plays a more overarching role. They're responsible for managing the CBAM registry. They also review CBAM declarations, and where declarations are incorrect or missing, they may assess the obligations based on the information at disposal and pass on this information to the national authorities, who then might or might not take action on this. So the Commission has a bit more of an oversight role, within the final implementing role lying with the member states. There's a penalty framework that will be there, whereby authorized declarants who fail to surrender sufficient certificates by the annual deadline face a penalty of about €100 per CO2 ton equivalent. That is indexed to inflation. And then there's also the obligation to surrender the missing certificates on top of that, where, of course, that's a financial liability of the importers. But as we discussed, that is likely to be passed on, depending on the contractual terms, to the suppliers. Then there's also, but that's a bit less relevant for exporters, any importers in the EU that import CBAM goods without an authorized declarant status face significantly higher penalties that can range to 3 to 5 times this penalty amount that we've discussed. So here we see a little bit these issues, and then there's the downstream implications for Indian suppliers, where, of course, there's a chain of consequences, whereby we're seeing increasingly that EU importers are working on schemes and measures whereby they can really shield themselves from any negative consequences of CBAM and pass these consequences on as much as possible to their suppliers themselves. And finally, briefly discussing the proposed downstream extension, which is also coming. Of course, also very relevant to exporters, and that really recommend that an eye is being kept on that and not lose this out of sight. There's on the 17th of December, 2025, the Commission published a legislative proposal to extend CBAM as from the 1st of January 2028 to about 180 additional downstream products. These were selected, these downstream products, as they have a high steel or aluminum content, an average about 79% by composition. And this also follows the EU's focus on steel and metals. It comes out of the EU Steel and Metals Action Plan that the EU came up with in March 2025, which identified also, among other things, a residual carbon leakage risk in downstream manufacturing. Now, there's a number of affected industries. Categories include fabricated metal products, machinery and industrial equipment, vehicle components, which is also relevant for India, and some domestic appliances, base metal fittings, industrial radiators, and so on. Over 94% of these are intermediate industrial goods, with only a limited number, around 6%, being household products. So again, the focus really is on more industrial intermediary goods there. This proposal is going through the EU's ordinary legislative procedure, which is a bit complicated. The European Commission makes a proposal. The Council of the EU, which represents the EU member states, has adopted a position thereon. You have the European Parliament that's also going through its process there, and they're expected to adopt their position in September this year, after which the Commission, Council, and Parliament will start negotiations on the final text. And it's currently expected to start entering into force as from the 1st of January 2028. But so there is already quite some information out there now that Indian companies can rely on to start preparing. Go through the list of products that are there, audit the product portfolios against the proposed list of products to determine whether any exports to the EU will fall under this expanded scope, and start already preparing by building the relevant infrastructure to be able to calculate your actual emissions and prepare for the verification thereon for these products, and also start engaging with your customers in the EU, potentially review supplier contracts, because this is coming. And what we've seen with the CBAM as it is in force now, that several industries, even though this has been going on for a number of years now, are still very unprepared today, even though we're already in the definitive phase. I'll leave it at this for the introductory comments, and I think we can move on to the panel discussion, and hopefully these introductory comments will serve for a nice and interesting discussion between the rest of us. Thank you very much.
Thank you, Byron. I think you provided us with a very, very good overview of the kinds of issues that Indian exporters really need to start thinking about today. And with that, I think in this next stage of the panel discussion, what I'd really like to do is delve deeper into what it is that the Indian exporters should start doing now, so that they are, protected against high penalties and default values in the future. So you mentioned that the CBAM was in a transitional phase for a certain period of time, and now the definitive phase has started. I'm sure that this phase would have been used by EU suppliers to, do a due diligence of their supply chains, reassess, their existing contractual relationships, and decide procurement strategies. So in this transitional phase, what has been your experience in terms of working with EU companies? How have they been assessing their supply chains, and what kinds of contractual changes and clauses have you seen coming up in these kinds of procurement contracts and other legal documents between EU importers and the exporters across the globe?
Yes, thank you. That's a very good question, and actually, what we're seeing, especially during the transitional phase, and even now in the beginning of the definitive phase, has been very patchy and inconsistent. A lot of companies, and this covers importers as well as exporters, have not necessarily been taking as many actions as they could have done to prepare for this definitive stage of CBAM, whereas others have been very proactive and have been putting several measures in place already. So it's been very inconsistent and even difficult to see a pattern in there. You've had some very large exporters of steel goods to the EU that have been working very hard on working on verification of their emissions with even some uncredited verifiers because their accreditation wasn't there yet, but really putting everything in place so that they can hit the ground running and starting. And we've seen other large exporters that have only been starting to think about this as from January this year, with the definitive phase already kicking in. And the situation has been a bit similar with importers in the EU, some of which were struggling during the definitive phase to really make all the reports during the transitional period, with others really focusing on this quite a bit and working hard and already auditing their suppliers, asking very targeted questions, and starting to look at contractual clauses and other such measures to put in place. What we've been seeing from contractual clauses that importers that have been ready and have been proactive on this have been a number of different elements that EU buyers have been increasingly embedding into supply agreements. Of course, one key element has been data accuracy warranties and representations, whereby the importer wants the supplier to warrant that emissions data provided or to be provided, because some of these are for further down the line in the future, would be complete, accurate, and prepared in accordance with the relevant CBAM methodology. We are also seeing measures relating to audit and inspection rights, whereby either the importer or a third party appointed by the importer could audit the supplier's emissions monitoring systems and production records. So a bit of an extra verification on top of the verification by the third party verifiers. Price adjustments and carbon cost pass-through provisions, whereby the contracts explicitly state that the CBAM certificate costs may result in price adjustments, especially if there is some unexpected results there or recalculation by the NCAs or the Commission of the emissions data. A very common one is also notification obligations, whereby suppliers must notify buyers promptly of any material change in production processes, energy sources, or emissions intensity that could have an impact on CBAM imports. And finally, indemnity clauses and termination triggers, whereby indemnity clause, that's pretty clear, but also termination triggers whereby an importer can immediately terminate a contract in case there is one or persistent failures to supply verified data or material misrepresentations. Now, how heavy and how strong and how many of these clauses that we see really depend on the negotiating power of the importer. If you have a small importer dealing with a large supplier, of course, there's less room for that importer to impose their contractual obligations on the suppliers. But where we have importers with strong buying power, and especially with smaller suppliers, there we are seeing sometimes much stronger obligations entering into the contracts.
Thanks, Byron. I think that is very useful information for any company that's doing business with the EU, and it really is the right time for them to take a relook at their contracts. One point that you mentioned about the accuracy of the data that's being reported and the contractual clauses that are being put in with respect to that, I just wanted to understand. I think I also have a question for Parth within this. Often companies, they will be reporting data at one point in time, whereas actual verification will happen at a later stage. So from that perspective, what is the margin of kind of error that's allowed, number one, within the broader CBAM legal architecture? Number two, within the contractual clauses that you're seeing itself? And Parth, for you specifically, I'd want to understand from an Indian company's perspective, how best to hedge the kind of risk that is associated with this, with the change in the numbers that might happen between your reporting and your verification. So I'd let both of you answer that question.
I'll briefly answer with respect to the margin of error. Of course, these are very detailed calculations, and small errors or mistakes are inevitable. But the idea is that, assuming that these are indeed clerical errors or errors in good faith, that they do not fundamentally alter the outcome, there's not really much of a, or at least not that we expect. We'd have to see how the NCAs deal with the enforcement, but we don't expect there to be many issues. This could result in a recalculation and that the actual emissions increase a little bit or something like that. That's not a big issue. You mentioned very correctly that verification will come later and that the actual calculation needs to happen now. There I'll let Parth touch upon that in more detail, but what has been expected, at least from the Commission's and from the EU's perspective, is that because we've had this transitional phase for a couple of years, that by now exporters and suppliers should have had sufficient time to put in place adequate measures whereby they can calculate their emissions. On the other hand, you can counter that with saying that the detailed calculation methodology was only published by the Commission in the implementing regulation very late in December 2025, and there were quite some changes there as well. But okay, let's leave that aside. But yes, it is very possible that through the verification by the accredited verifiers, the data will change somewhat. Now, that is more of a private issue between the parties, and I'll let Parth touch upon that in more detail. The idea is that once it's been verified, and it's that declaration that will be used and submitted in the CBAM registry, that hopefully at that stage there should not be any real issues. Also there, what suppliers can also look at is contractual obligations that they pass on to the verifiers, for instance, if they do not adequately verify their data. But I'll pass the floor to Parth to answer the other part of the question.
Well, thanks, Byron, and thanks, Naghm. I hope I'm audible. I mean, this is a very important question to my mind. Look, a company, after having put all in efforts in order to, comply with CBAM, and then if you are not, cautious enough to have relevant contractual setup or framework, then all that efforts which have been put in could be, could go in futile, because then you're looking at a situation where the contractual dispute itself take away the whole benefit or competitive benefit of complying with CBAM. So to my mind, I think the fundamental point is that both parties, the supplier from India and the importer, they must recognize that, as Byron also said, there will be some amount of change always, right? We are talking about very complex calculations. Verification, post-verification, when the data is actually, scrutinized, there will be some room for changes. And I think the contracts both parties should recognize that there would be some amount of adjustments. There should be some scope of true-up made in the contract to begin with. Now, what is the range in which you can go, right? That's where parties need to agree. You can't really have that numbers are so significantly different that it entirely changes the economics for, let's say, importer from the EU side. Nobody is going to take that kind of liability. So I think at the end of the day, it's very important for parties, as they are reporting their data and it's going to be scrutinized and verified subsequently, that the contract itself provides for certain readjustments, and those readjustments should be upfront, be agreed in the ranges that it will have. And thereafter, there should be allocation of responsibilities between the parties in terms of liabilities which they are likely to assume or not assume, because that kind of contractual certainty is required. It avoids, unnecessary and avoidable disputes at a later stage. And this certainty is pretty much required. Otherwise, you're looking at an uncertain situation, and then you don't really know the exposure to which the business exposure, the monetary liability exposure which you will have, right? And we have been advising some of these clients to that effect in terms of how they should look at contract. And this is only from perspective of hedging your risks. You should also look at the other general parts of the contract in terms of how the disputes will be resolved, because disputes with respect to calculation and subsequently price adjustments and all of that. This also requires technical understanding. How do you want to resolve those disputes? Would you like to take it directly to an arbitration, general arbitration clause? Are there other ways in which you can resolve it, right? Parties should also think about that. So that's what I feel about my senses on how the contract should be right now looked at. I'll pause here, but happy for Byron to add if you.
No, I fully agree with that. And I think we also need to be a bit realistic in that despite the transitional phase that we have, it's still going to be a bit of a learning experience and a learning curve for all parties involved. This includes not just the exporters, the importers, also the NCAs and the Commission. And I do think that as time progresses and that we will see certain types of issues arise, that maybe also the contractual clauses that we're seeing might evolve and change. Also, probably in the beginning, there might be some more problems when the suppliers start with their calculations of the actual emissions and then the verification thereof. But hopefully after 1 or 2 years, once this starts becoming a bit more less of a new and daunting task, but a bit more part of normal operating procedures. Hopefully there we'll be seeing less issues. Because what we're seeing now is that EU importers are very concerned and will want to impose certain contractual obligations, but at the end of the day, that might also differentiate suppliers, maybe a supplier that might have certain price issues or might not be able to immediately provide the same level of data, might be willing or might be forced to accept more stringent contractual provisions, where maybe other producers that are much more prepared and much more able to provide proper actual verified emissions might have less of an incentive to accept very onerous contractual obligations. So I think that there we're still going to see a little bit of an evolution and changes, I think, as time progresses and that we all become a little bit more acquainted with the actual implementation of the definitive phase.
Thank you both. So just building upon a bit more about this whole issue regarding contracts. Now, companies in India would be selling to a wide variety of importers in the EU. So we will probably come across situations where an exporter in India is selling to multiple EU customers. And I just wanted to understand that how best would they be able to navigate the whole process of the CBAM, ranging from the emissions data to the reporting and to the contractual clauses. Because it may be the case that different companies would require different levels of compliance, different levels of report. Is that something that you have seen, that different levels of reporting are being witnessed, or is it something that one emissions report would be used across the board and that would how it would go?
So actually, what suppliers can do, and which is the most recommended approach, is that they can upload their own full verified emissions report into the CBAM registry, because these full reports contain actually quite some confidential information that you don't necessarily want to share with your customers or with any other parties. So there's the possibility to upload the supplier by themselves all the relevant information into the CBAM registry, and then importers can just rely on that information for the purpose of their CBAM declarations. They will get a summary verification report that will allow them to review to a certain extent some of this data. Now, there's been some complaints from a third country producer that even this summary report still contains a bit too much confidential information. But this is the theory and the principle that suppliers, especially larger suppliers, will upload their verified emissions reports themselves onto the CBAM registry, and that is what then the importers and the declarants will be relying on. Because the alternative means that you would have to provide the full emissions verification report to your customer in the EU, who will then be uploading that and relying on that. You don't really want to do that because that contains too much confidential information. So assuming that you're relying on this system whereby it is uploaded by the producer, the supplier itself, then it's relatively easy to say, well, I don't need to provide you with much more information. I'm complying with the framework. It's there in the thing. It has been verified. Now, the reason why the importers will still be getting a summary verification report thereof is that because the obligation lies on them, so that they can still review and then ask some questions. But hopefully that can be fairly limited, and especially if it's a sophisticated producer, can have some standard answers and responses ready to respond to any questions that might be there. Indeed, also, as you mentioned, with respect to contractual clauses that importers might be asking, what I would recommend, and Parth, I'd like to hear what you think about that as well, is that especially if you have a lot of exposure of exports to the EU and that is important for you, that you have standard contractual clauses covering all these elements that we've discussed and that we're seeing, that you might not necessarily all will have to rely on if you have an importer that doesn't care too much and is fine with some more limited contractual clauses, but that you start with your standard contractual clauses and that you're a bit proactive, that you send those to your supplier, say, hey, listen, these are our standard CBAM contractual clauses. And then as in the context of any contractual negotiation, there will be some back and forth on that probably. It's possible that your customer in the EU will have their own standard contractual clauses as well that they want to work on, but then at least that gives you a basis, a bit of preparation, and a first step that you can have something to rely on.
Right. So I think the key takeaway here is that exporters in India need to be proactive. They need to reach out to their suppliers. They need to understand what the expectations are, have their own standard contractual clauses in place, and then take it forward. So that's very helpful. So looking forward to the future, CBAM is presently limited to certain sectors. But in 2028, like you mentioned, it will be expanding to several downstream sectors as well. So sticking to the theme of being proactive, what can Indian exporters that could be exposed to CBAM in 2028 do now? And I'd like to ask this to Parth from an Indian exporter's perspective. And it's particularly because my understanding is that there will be no transition period provided to those downstream industries. So how can an exporter be proactive, and what can they do for the downstream industry coverage that's expected in 2028?
Oh, thanks, Sam. Yeah. So one thing is there is lack of clarity in terms of whether there will be a transition period or not. And again, I always say our clients that uncertainty is the biggest evil when it comes to business, and therefore, if regulatory uncertainty is there, make an attempt to be. Try and hedge against those business uncertainties. So my recommendation immediately is that even if downstream products are not today covered, and knowing that CBAM is a regulatory regime, which is kind of a moving regulatory regime, and we all know that the scope will be expanded. It's just a matter of timing, right? It's important that you start organizing your business as if you are covered. Start collating data. Look at what your emission levels are. Identify, do a complete due diligence, what your supply chains are, where are the pain points when it comes to emission levels. If you have a particular input which you're using and the emission levels are getting higher because of a particular input, see what are the alternative sources. Talk to your suppliers where they can provide you reliable information with respect to their own emission levels, right? So this preparation is important because, like you said, and I will refer to Byron as well, there is no clarity whether there will be a transition phase as was with the original case. And at the end of the day, I would say the guiding principle or the North Star for CBAM compliance is don't look at it as a regulatory cost. If you're serious about your business in the sense that you have a business exposure to European Union, whether directly or indirectly, then treat law as reality. CBAM is going to stay, and therefore treat it as a competitive tool. If you're more affordable, if you're more competitive in terms of your pricing, it is only going to give you a better market access or wider market access ahead of your competitors. So at this point in time, take all the preparatory steps, do a full supply chain due diligence on terms of emissions, see how you can best optimize your carbon emissions, and be ready. That's what my suggestion would be for downstream producers at this point in time.
Right. So I think the key takeaway from that is that we need to look at CBAM beyond just compliance. We also need to look at the competitive advantage that it could potentially bring to Indian businesses, not just in the EU, but also across the globe, as various other countries are also taking similar measures. In fact, there are countries like the UK that are already considering the CBAM. India too is working on carbon credit trading domestically, and I know that Parth has some expertise in that. We Byron, you had mentioned that carbon prices that are paid domestically can lead to a corresponding reduction in the amount of CBAM certificates that are to be supplied by the EU importer. Parth, I just wanted to ask you, how do you see the Indian carbon credit trading scheme operating within this broader framework of the EU CBAMs that may be introduced by other countries? Do you see a opportunity for some kind of convergence, or do you see it as more a parallel track that Indian exporters and Indian producers will have to comply with going forward?
So I would say that it has two kinds of effect, right? Well, as India, evolves into a more robust and I would say more formal carbon credit trading system, it will have a direct and indirect effect both. What do I mean by direct effect? So a direct effect is that the moment the covered sectors, or at least regulated sectors, the moment you are covered in a trading system, obviously, which means that the businesses are going to be likely to be more carbon sensitive, right? It has that impact. It's not the case that everyone is going to really buy carbon credits, continue to consume carbon or emit carbon for that matter at the same level and trade it off with buying certificates. There is always an impact where businesses do become more emission sensitive, right? And that in any way, to the extent these covered sectors overlap with any kind of or CBAM or CBAM type laws, whether in European Union or outside EU, to the extent there is overlap in those sectors, you are in many ways also lessening your carbon emission, and to that extent, you are also making your product more price competitive. At the end of the day, CBAM is nothing but it's a carbon cost, right? Then there is a second element to it, which is that to what extent the carbon prices which you're paying within your home country can be adjusted towards a carbon cost in some other country, right? And that's where the question of interlinkages and recognition of cross-border recognition comes in. And I think there is a lack of clarity on that at this point in time. Whether a trading system that India is conceptualizing at this point in time, whether that will be fully recognized or not, that's an open question. There were some developments recently on that, but I will still peg it as an open question. And so it remains for other CBAM-like instruments that might come in other jurisdictions. So one, like I said, one is, of course, there is businesses are going to be more carbon emission sensitive, which is going to ultimately favorably impact their pricing. And two is, of course, this recognition and therefore cross-border recognition, whether you can link them together, right? And that's an open question. But my sense is that at some point in time, there is likely to be convergence and not fragmentation, because more the fragmentation, it is likely to be more difficult. And I think with the mushrooming of bilateral level trade agreements and all, I think the moment you see more such domestic laws coming up, I think governments will be conscious of that, and there is likelihood of a greater convergence on this.
Just to touch upon that, I think that's a very good point, and I think there the EU, in a sense, for themselves, were smart to have the first mover advantage because, as Naghm already said, the UK is working on its own CBAM framework, made quite some progress there as well, and you see it's really to a large extent mirrored on the EU system. The UK also has its own ETS, and what we're expecting to see is that at least for those countries that are closer to the EU in terms of trade policy and that see closer alignment with the EU, that we might be indeed seeing some form of carbon pricing in those jurisdictions being developed. And of course, I would expect that those jurisdictions will try to a certain extent do it in such a way that this can be taken into account for the purpose of CBAM. Now, some jurisdictions that are maybe less concerned or are fundamentally more against this might do this to a lesser extent. That still remains to be seen. As Parth also mentioned, it's still very unclear how this will work in the EU for the purpose of CBAM. That's something that the Commission is currently reviewing, and they had a consultation on this, on how exactly carbon price paid in the home country should or could be taken into account. So yeah, this is probably going to be an area where we're still going to be seeing quite some developments, both on how this will be taken into account in the EU, but also how this will be moving in other jurisdictions.
Thank you for that, Parth and Byron. I'm conscious of the time that we have left. So I'd like to, unless there is any other topic that either of you want to address, I'd like to open this up now to the audience. There are some questions that we've received in the chat box. So I would start with, addressing those. So one of the questions that we've received is, what is the most reliable way to determine whether a product falls within a CBAM scope, particularly where a product is a process downstream or composite item?
I'll give our perspective there. It's actually currently still fairly straightforward to determine whether or not a product falls into a CBAM good. Go to the annex of the CBAM regulation, and there in the annex you have a very long list of goods per CN code, so the EU customs code, basically, and on that basis you can identify any goods that fall within the relevant customs code will be covered by the CBAM scope or not. And with exporting to the EU, the customs code should generally be known, so it's just an exercise of checking whether the customs codes are covered or not. With the scope extension of the CBAM, the expected extension that will probably start as from 2028, will start becoming maybe a little bit more complex. The approach will be the same. It will be based on the customs codes, but of course, the more upstream you are, the easier it is to determine potentially the customs code of a product. The more complex products become, the more difficult it might be. But at this stage, it's fairly straightforward. You rely on the customs code, and then you can identify whether or not the good is covered.
Thank you. I think that's a very straightforward response, and I hope that answered the question. Another question that we've got in the chat box is that our company exports through an intermediary to the EU. Will we still be expected to provide emissions data, and if so, to whom?
Well, yes, because for any CBAM covered goods imported into the EU, emissions data has to be provided. The declarant will have to submit this data. They will be requesting, obviously, this data from their supplier. But if the supplier is a trader and cannot provide this data, of course, the trader will be requesting this input from their supplier, which will eventually end up with the upstream producer. You can decide as an upstream producer not to provide this data to either your supplier or the EU importer, or even upload it into the CBAM registry, as we discussed earlier on. But that will mean that the CBAM declarant, so the importer in the EU, will have to rely on default values, which are in most cases going to be higher, if not significantly higher than potential actual values. And that might mean that the importer in the EU will not want to import from the trader, which will then also mean that the trader will not be buying from the supplier. So it's just a little bit of a domino effect. Of course, if you don't care too much about this trader, then that's fine. But if this trader is an important customer of yours, then a way must be found for this data to find its way to the CBAM registry.
Parth, you're on mute.
Sorry, I just wanted to add, I mean, everything that Byron says, I completely agree and makes a lot of sense. And this is what we have been advising clients as well. Don't look at EU as your direct market. I mean, today's world is an integrated supply chain. And if you are providing something to UAE and from there goods are going to European Union, and if those goods are covered goods as we speak today, and of course, when there is a scope extension, we are talking about a wider set of goods. You will lose competitiveness if you are not, number one, able to collate data and provide it to the buyer in UAE who is going to use it to produce the finished goods. And two, your product itself will be, priced higher if you are not doing all of that. So I think time and again, we are trying to say in every webinar, otherwise in the conferences which we have attended, treat CBAM as a competitive arbitrage and not look at it as an additional burden, because this is going to stay. And as Naghm, you were mentioning, we're only going to see more and more mushrooming of laws like this. So in today's world, you really need to take it as if they do exist and they will continue to exist, and how best you can use it as a business strategy to beat the competition.
Thank you, Parth. I don't think we have any further questions from the audience. I think it's been an extremely useful session today. We've had a chance to deep dive on what it is exactly that Indian exporters need to do. And I think the message is very clear. CBAM is not just a compliance cost, but it could potentially be a competitive advantage. Exporters need to be proactive, particularly the downstream industry, which still has a period of time to prepare and ready itself for CBAM. And definitely, this is something that I think we're going to see Indian companies taking on more proactively as time goes on. This has been a really insightful session, and I thank you, Parth and Byron, both for taking the time out to join us in episode 2. Thank you for being here and for giving us your time.
Thank you very much.
Thank you very much. Thanks, Byron. Thanks, Naghm.
Thanks to both of you as well, and thanks for having me on.